Good morning, everybody, and hope you're enjoying your lunch. I have limited standing room here, so I'm just going to sort of hang out about here. So I'm going to talk a bit about corporate governance, information governance, and records management, just to set the stage. Then kind of the main event is 2 and 3, paper versus digital, and I'll talk a bit about replacing paper with digital. And then I've got a whole bunch of slides, probably too many, on records management. But I brought them with me, and they're in your materials for a reason, is that they're kind of standalone. You can actually read them and hopefully make some sense out of them, as much as you can make sense out of anything I write. Also in your materials, there's a short paper on the Electronic Transactions Act and functional equivalency that might be useful for you, because I'll be talking about that. And there's also a paper on best practices in e-discovery and records management. So one other thing I should tell you is I'm a founding member and currently national co-chair of the Sedona Canada Working Group in Electronic Evidence, which has published some best practices, first in 2008 and then again last year. And those have been incorporated into the rules of court of some provinces, notably Ontario, and cited in court cases as far away as Ireland and Australia with some approval. So we're pretty proud of it. How did I get on that? I got a phone call sometime around 2005 or 6, asking me if I knew anything about screen scraping, and I said yes, and I started explaining it, and then I was told they didn't want to hear the explanation, they just wanted to know if I knew anything about it. So I ended up being on the Air Canada and WestJet case, on WestJet's side. So I was kind of the backroom geek that ran that case, e-discovery part of it, and all the electronic records that we had to deal with. And out of that, all the lawyers involved in that decided that Sedona Canada would be a good idea, so we started it up. So without further ado, a bit about governance. Corporate governance is a hot topic, obviously. That's kind of the highest level area of corporate management. And I've written down here some definitions of it, but I think we all know basically what it is. It's properly running corporations. Underneath that is a subset called information governance, more and more important nowadays as we move further and further into the so-called information age. It's a subset. It focuses on information and technology. It includes records management. And an important point here is that how many records managers in the room? I know there's at least a couple of you because I know you personally. You differentiate, or at least most of you do, between a record and a document, and you think they're different things. Lawyers are far too stupid to figure that out, so we just think they're the same thing. Some rules of court will call them records, other courts will call them documents. They're just basically information in some form that we see as having some legal relevance. In that case, we don't care whether you call it a record or a document. If it's available and it's got some relevance in a lawsuit, we want it. So I will use the terms documents and records quite interchangeably, so we all know what the terminology is. So why keep records at all? I mean, fundamentally, sometimes it's good to step back to the very first step in these things and say, well, why do we do that? Well, we have an operational need, obviously. We need to run the organization. And from that flows the fact that if you're going to run an organization, you want to have the records you need right now because you need them. And you don't want to have a whole pile of records you don't need because they just get in the way. And from a legal point of view, you need to have records for certain legal requirements. There might be a statute that says you must keep this record and you must keep it for X years. You might have audit records, you might have governmental inquiries. And if you're sued or if you're commencing a lawsuit, you have obligations in civil litigation to find and preserve relevant records or documents and produce those to the other side. And sometimes even if they hurt your case, you have to do that. So we have business reasons to keep records and we have legal reasons to keep records. If anyone can think of a third one, let me know. You might have license or permit requirements. That's probably legal. You might want to enforce or defend your rights, so you want to keep copies of contracts you signed. In case the other side breaches a contract, it's kind of handy to have a copy and say, here's what you agreed to. Title documents, you can prove you own your house or that oil well or whatever. Evidence for whatever legal reason, and to defend yourself in litigation or to prosecute a lawsuit, you need records to prove things. So let's talk about paper records versus digital electronic records. The information may be the same in the two types of records, but there's lots of differences. So most paper now originates electronically. And I went out on the internet and I found a whole bunch of statistics on what percentage that is. And then I read a really good statistic, which is that 97% of all statistics are just made up. Stephen Wright said that, he's a comedian. So whatever percentage it is, it's a very high percentage. It starts in a computer somewhere. It doesn't start as paper unless you're handwriting, pretty much. Nearly all records are now digital. Many of them never exist as paper, and they may never be used. There's lots of records that get created and no one ever even looks at them. They're everywhere. And many records may never be seen by humans at all. Computers keep a ton of records in the background, in the operating system, and in records management protocols and network systems and so on. And humans may never see those. But from the legal point of view, we actually don't differentiate. If it's a record and it's relevant, we don't care if it's in binary form or English or Klingon, for that matter. Don't laugh, there's a court case going with Klingon right now as to whether or not it's subject to copyright. There are people in California who think Klingon immersion schools for their kids is a good idea. Go figure. So we're nearly there already. Most of our records start out electronically and then we print them out. I don't fit my demographic, but a lot of guys in my age group tend to like paper. I personally hate it. I find it very dangerous. It's always cutting my fingers, and I just don't like it. So why create electronic records and then print them and have the electronic record, and then we got the paper record, now we got two records? Or why scan paper to electronic format but keep the paper? Maybe make a couple of photocopies just to have them around. You know, I remember when I was a very young lawyer, I was told you need 4 copies of this document. Why is that? You need one for the court, one for us, one for the other lawyer, and one just in case. In case of what? Nobody ever answered that question. But now you've got paper copies that started electronically, they've been printed out, now someone scanned them back in, and then guess what you're going to do next? You're going to print it back out again, right? So now you've got 4 copies of it. The legal system may, and in most cases will, treat the electronic version as a separate document from the paper one. So if you have 10 million electronic documents that are relevant in a lawsuit and you print out 10 million copies, you now have 20 million records you've got to provide. That's the Department of Redundancy department. Think about it. It's just extra stuff we don't need. So, by the way, some of the slides up here are not in your materials for copyright reasons or plausible deniability later on. Although I am familiar with the case, and this is just kind of a war story, where a number of investors had seen a PowerPoint slideshow in a boardroom and relied on it and ended up in litigation. And copies of that slideshow were produced by the various lawyers involved, and the witnesses all said, no, that's not what we saw. You know, and they were pulling it off various people's laptops and so on. They finally found a copy of the actual PowerPoint slideshow that people would testify they had actually seen, and it was different. And the only copy was located in the cache memory to a television set in the boardroom. True story. A record that was discovered there. So let's talk about the difference between digital and Granddad's records, okay? Here's Granddad. This is in 1954. The Rand Corporation created a mock-up of the anticipated computer of the year 2000. And the spooky thing about this is this guy looks a lot like my own father. Actually, it was a hoax, but it still illustrates the point. So paper was simpler. You could see all the content on it except for disappearing ink and all that, you know, kid stuff. The number of formats was limited. It was 8.5 by 11 or legal size. It was white or blue or whatever. What you saw is what you got. And generally, you categorized it and indexed it and filed it somewhere, or you just threw it away. And it wasn't dynamic at all. It had, you know, once you put stuff on it and printed it, it was what it was, and it would stay that way until it eventually oxidized and flaked away or disappeared or someone lost it. It was also less convenient because it's not fully searchable. There's nothing worse, as a lawyer at least, to the other side giving me 18 binders of documents. 20 years ago, when I used to litigate cases with paper, I used to lay out all the binders down the hall standing up and measure them, and I always was looking for a 20-footer. I got to 18 feet on one case, but I never had 20 feet of binders. So I didn't really litigate the big cases, obviously. But it wasn't fully searchable. It's not random access. You can spend days hunting for it. You can spend a lot of money trucking records back and forth. And when you copied it, like with a photocopier, and then you copied the photocopy and so on, or if you took VHS tapes, for example, and made a copy, the quality degraded and so on. Plus, you had to spend money copying it. Electronic records, first of all, they take up a lot less space. And I got an illustrating slide coming up. They can be indexed and searchable. You can get them to come to you at light speed or close to it. There's some tiny fraction of a percentage off when photons move over the internet from light speed. And it can display the same information in a multitude of different ways. You can actually ask it questions, and it'll give you the stuff you want. For example, maybe 15 years ago, one of my partners was late on a Friday, and I think we were the only 2 people left, and this is in a different law firm in a galaxy long ago and far, far away. Asked me if I could help him print out an Excel spreadsheet so he could take it home for the weekend. And I said, "Are you really sure?" This is a guy quite senior to me. He said, "No, I want to print it out." I said, "Okay." So I let it run till the printer ran out of paper, and I pointed out to him we were about 1% there, and did he have a pickup truck? So he got the point. Electronic records have a lot of quality that, if properly managed, it enables data and information processing. It has metadata, data about the data, to enable processing and searching. The documents can be related to each other, can be a lot less costly and a lot more green. Distribution, we're distributing information. We're no longer moving atoms. Paper's composed of atoms. You know, it weighs something and it takes up space and you have to put it in a truck and haul it around. With digital information, you're just moving bits, which are weightless and move very quickly. And you can put a lot of them in a small place. Of course, paper has some things that digital doesn't have. It might have DNA on it, human or otherwise. It might have fingerprints, and in my office in the old days when I used a lot of paper, it might have coffee stains. I was about 6 minutes at the bar when I spilled coffee all over the original of a divorce petition. And thought, I'll just kill myself now and get it over with, but we managed to work around it. So when Granddad was around, a telephone call was very different from a telegram or a document or correspondence or a photo or music or video, television. Now it's all just data. So in 1996, I was doing an MBA and I wrote a master's dissertation that predicted that television would be streaming on the web by the year 2000. In other words, I was thinking about Netflix. It didn't happen in 2000, but it's definitely here now. So electronically stored information, or what we call ESI, has a whole bunch of advantages, but it also has some issues you have to deal with. They're all easy to deal with, or at least possible to deal with. But when you digitize paper, which you can do, and I'm going to explain how you can do it, and you now have electronically stored information, there are issues that you now have that paper didn't have. And you have to think about them and deal with them. And it's usually, you know how realtors say location, location, location? With information, it's policies, policies, policies. It's all about policies. So you can proceed with a bit of caution, a bit of thought, and a plan to digitize paper, but you have to think about the issues that will arise when you now have everything digital and nothing paper anymore, or very little paper. So massive volumes of paper can be replaced. I'm going to show you an example of just how profound this is in a second. And you can take all that information and store it in a much, much smaller space, keeping in mind the likely limited situations in which you want paper. One is, do you have a workforce of my age group, in which case they may demand paper, but tell them no. And there is a thing called digital paper that's coming rapidly. If you go into a JCPenney store, and this has been the case for almost 20 years, in the United States, you'll see these signs hanging with prices on them that look like paper. They're actually not. They're a digital display that looks like paper. So we can replace this. This is my basement with old files. Or this is the Library of Congress in the United States, the largest print collection on earth. And here's a couple of back rooms in the Library of Congress. You can put the Library of Congress on these 4 drives and have some space left over. Each of these is 4 terabytes, $200, $250 at Memory Express. I don't know, I haven't quoted them lately. You can put the entire print collection, not the video and all that stuff that the Library of Congress has. You can put the entire print collection, which is pretty much every printed book ever published on earth. My mother wrote a book of poetry that published 10 copies, and one of them is in the Library of Congress, believe it or not, because she sent it to them, and they'll put anything on their shelves, even my mother's poetry. So you can get all those books in 10 terabytes on these 4 drives, which are actually 16 terabytes. All the tweets ever sent by Twitter are only 20 terabytes. So that's 200,000 trees for each one of these drives, 800,000 trees. Now, very small. So let's talk about digitizing the paper from the legal point of view. There's a whole bunch of law out there. It boggles my mind. I'll start talking about the Electronic Transactions Act, for example, for lawyers. And a few lawyers that don't practice in this area will say, well, when did that come into effect? 2004. It was proclaimed in force. So it's been around a while. So Alberta, and I'm going to talk mostly about Alberta, but this will port over to other jurisdictions, has an Electronic Transactions Act that enables digitization of records, and it has amendments to our Evidence Act that enables evidence in electronic format to be admitted into court, and there's rules around how you prove it and how you authenticate it and those sorts of things. Whole piles of regulations. The rules of court now deal with it. Sedona, Canada deals with it, for example. Most of the courts have practice notices to lawyers saying, here's how we're going to do this. And lots of case decisions out there, tons of them. Publications are standards as well. These don't necessarily have the force of law unless you somewhere or other contractually agree to comply with them. But the Canadian General Standards Board has standards on documentary evidence in digital format. Sedona, Canada, as I mentioned, there's lots of ISO standards. There's ISO standards for everything. The width of toilet paper, this clicker probably has an ISO standard. There's lots of accounting standards, SAS 70, for example. and various industry standards like the payment card infrastructure for electronic transactions online using credit cards. So a lot of security rules and so on built into that. So it's not that we don't have any law governing this, it's that we almost have too much. There's lots of enabling legislation out there. And it tends to be permissive, not mandatory. It doesn't say thou shalt use electronic records. For the most part, it says you may use electronic records in most cases. So we'll drill down into that a bit. Let's talk about e-commerce legislation. This goes back to about 1980 with the Organization for Economic Cooperation and Development, the OECD. Came out with a model e-commerce statute. Canada had a model e-commerce statute back in the 90s. And eventually, all the states and provinces in North America got some form of e-commerce statute. Unfortunately, they didn't all sit down around a table and get the same one. So the rules differ as soon as you cross a border. They may be the same, they may be different, they may be so close you can't tell the difference, or they may be dramatically different. But all the provinces and territories in Canada have an e-commerce statute of some kind by some name. The Northwest Territories was the last one a few years ago. They brought theirs in. There's lots of common law decisions on this as well. So I don't have this slide, but I find it kind of cool that I'll ask people, when do you think the first e-commerce case was decided? And there was a case in the United States around whether or not a communication over a wire was writing as required by a statute to form a contract. And the judge said, I've read the statute, and to me it matters not whether it's a quill pen or a copper wire 1,000 miles long. This is a contract in writing and the statute is satisfied. That was in 1859 in New Hampshire. And in the 1850s, believe it or not, people were meeting online by telegram and getting engaged and then meeting face to face, and they were doing business and all kinds of stuff in the 1850s. So just nobody around remembers it anymore, but a lot of what we think is new and cool, not really new and cool. Just different. So lots of other legislation, like privacy legislation, for example, industry-specific legislation. No matter what industry you're in, you're going to have some kind of statute that applies to you that says you must keep this type of record for this many years. You must have it in this format, maybe. It often doesn't say that. Sometimes it'll say only electronic format, and sometimes it won't say at all. So the Alberta Evidence Act now defines an electronic record. And keeping in mind that electronic and digital, not necessarily the same thing, but usually when we're talking electronic with modern technology, we're talking digital. But technically a VHS tape or those old cassette tapes, nobody here is old enough to remember those. You used to put them in a hole in the dashboard in your car and music came out. They were a little cartridge, they had a tape inside, never mind. Those were technically electronic, but they weren't digital. So there's the definition of electronic record in the law. There's what an electronic record system is. It's all very technology agnostic, neutral. It doesn't say an electronic information system is Windows or Unix. It doesn't say that. It leaves it very open. So the Electronic Transactions Act, which amended the Evidence Act in Alberta, doesn't require a person to use provide or accept information without their consent. Having said that, if the only record that if they ask you for a record and they have a legal right to it and you say to them it's only electronic, sorry, tough luck for them, they got to take it. But consent may be implied, and this is really talking more about whether or not you're dealing online. So if I log on to Amazon and buy a book in the Kindle edition, I've obviously consented to transact and contract electronically. And I'm not going to be able to say, well, it was electronic, so it's not legally binding. I mean, that would be stupid, frankly. So this statute just confirms that you can do that. Doesn't cover all records, there's exceptions. But if it falls under the Electronic Transactions Act, and you'll see that in the functional equivalency materials in the folder I've set out for you, it can't be denied legal effect just because it's electronic. That's no defense to say, well, this isn't legal, it's electronic. And a requirement for a written record can be satisfied by an electronic record. So if you have a legal requirement to keep a sheet of paper for 7 years in case the government wants it, and nowhere does it say it must be paper, you can probably shred it once you've scanned it and converted it to electronic format. And the electronic format's good enough as long as you follow the rules. I'm going to talk about the rules. So major exceptions though. Any record, and this gets kind of tricky, it's like the old saying, you can get 2 lawyers and ask them a question, you'll get 3 opinions. So records that create or transfer interest in land, including mines and minerals, are not subject to this. So do not think that if that record relates to an interest in land that you can scan it and then shred it, because you may find out that what you have left is not enforceable. So that's carved out. Some things that may not matter to companies, but wills, codicils, and the trusts they create, enduring powers of attorney, those sorts of things. negotiable instruments and personal guarantees. So my old joke that I emailed you my check means I didn't email you anything valid, because you can't have a check in electronic format. It doesn't work that way. You can transfer money, but not by a paper check. And records exempted by legislation. And the notable one in Alberta, and I still don't know why this is records under the Employment Standards Code that you have to keep for 3 years after employment ceases. Apparently they have to be paper. And I don't think everybody's following this, frankly. I'm certain they're not. I haven't seen any cases coming out of it. So electronic includes created, recorded, transmitted, or stored in digital form or in any other intangible form by electronic, magnetic, or optical means. I mean, this covers everything imaginable. It's a very broad definition. And electronic signature. We now have those, by the way. You can sign things electronically. You've probably done that already. But electronic information, and it's interesting how this is defined. It's something that a person creates or adopts in order to sign a record. And when you talk about signatures in the old days with paper, you know, some kind of scrawl, as long as the person did that scrawl with intent to be legally bound, that was a signature. I mean, my signature and my initials are identical. I used to have a very elegant, nice, legible signature. Then I went to law school and I started signing a lot of documents. I just said, the hell with that. So I did have a problem with my bank, though. They said, that's not a signature. I said, it is now. So they don't have the right to dictate that to me. If I sign something with intent to be legally bound, it's a signature. Same thing electronically. So if it's in the record, like typing your name at the end of an email can be good enough in the right circumstances. Or if it's attached to the record somehow, or if it's associated, like maybe with a link, a hypertext link or something like that. Any one of those mechanisms can be a valid electronic signature. In fact, they're a lot more secure than paper signatures, because you can have password protection, it can be encrypted and so on. Here's the cool part, electronic agents. My computer formed a contract with your computer. That actually happens now. In fact, it's not even that new. And I'll tell you why in a minute. But this means a computer program or some other electronic means that can basically carry out some part of a contract or a transaction, either with a human, like when I log into Netflix and buy a Kindle edition, or with another computer. So back in 1973, you could walk into a Walmart in the United States, and in those days I could say I need a size 28 pair of Levi's. It's a little larger now, but we won't talk about that. And as soon as those Levi's came off the shelf and I paid for them and got them in a bag and walked out of Walmart, Levi's knew, because Walmart in the 70s had electronic data interchange, and they had all their suppliers, all their major suppliers, linked in, pun intended, to their systems. So supply chain management was being done by computers. And the humans had made an agreement that said, when this computer orders more jeans from here, this is the agreement. We'll ship what the computer's ordered, and you will pay us what the computers have agreed to as the price. So this is actually not all that new, but now it's in statute form. So let's talk about functional equivalency. That's kind of a buzzword. So the Electronic Transaction Act really runs on functional equivalency, and fundamentally what that means is we're trying to have an electronic version of the paper that has the equivalent functions, so it works the same way, basically. So if you have a requirement to provide a written record, you can generally satisfy that with an electronic record, as long as you're not one of these things like interest in land that are excluded from this, as long as the record's accessible by the other person so that they can use it for subsequent reference. And you can disable that with computers. But if you do, you'll find it's not legally binding. And it has to be capable of being retained. So if you have an electronic contract, do not disable printing and do not disable saving, because it's not functionally equivalent to paper. It's like you sent someone paper that's going to catch on fire, you know, like this message will self-destruct and the secretary will disavow all the knowledge of your actions. So as long as you functionally comply with these requirements, you've probably got a legally binding version, electronic version of what once was paper. If there's a requirement to provide or examine an original record, that can be satisfied with electronic records as long as there's some kind of reliable assurance as to the integrity of the information contained in the record. That's a lot of gobbledygook, and the short answer to that is as long as the electronic record says what the paper record says, you're good. The criterion for integrity is whether the information has remained complete and unaltered, and with electronic records that's always an issue. It's much easier to modify them than it is paper. Apart from the introduction of changes due to normal communication like metadata, like date saved, date printed, that sort of stuff, it's determined, this is right out of the statutes, it's determined in light of all the circumstances, including the purpose for which the record was created. Now, as a lawyer, I read this and I start thinking, ka-ching, because when you get into litigation with electronic records, there's more issues now, the difference between digital and paper that I talked about earlier. So we can explore those differences. A legal requirement that a record is signed to satisfy an electronic signature, but it has to be reliable to identify the signer, and it's reliable in its association with the record for that purpose. Well, that's no different than a signature on paper. You know, it has to be reliable to identify the signer, or is that his signature or her signature or not? If it's not their signature, it's called forgery. And it's always been around as a problem. Before the invention of the fax machine, people forged signatures. After the invention of the fax machine, people photocopy signatures and merge them into a document and fax them and hope they'd look good enough to pass muster. Nothing new. This has been going on forever. And by the way, the famous Nigerian letter, you know, I have $1 million and you can help me get it from the estate of my dead uncle and so on. That goes back to the 1750s when it was circulating in paper form, believe it or not, and it actually worked in those days, and it's just easier to do with email. So as long as you fulfill these requirements, which really aren't that different from a paper signature, you're good. Now, legal requirements to retain records. If it's originally paper, the electronic must be in the same format as the original, so it's got to look the same. It's got to accurately represent the information in the original, and it's got to be accessible so to be used for subsequent reference. That's not any different from paper either. I mean, if you're going to rely on a paper record, it's got to be the same format, even if it's a photocopy. It's got to have the information in it accurately, and it's got to be accessible. You've got to be able to find it, which with paper can be a real problem, because what box is it in Iron Mountain out of the 10,000 you have over there? You saw a picture of my basement. You know what I'm talking about. The person seeking to introduce an electronic record in evidence has the burden of proof of authenticity. That's the same rule with paper. If I want to introduce a document in court, I got to prove it's authentic, whether it's paper or whether it's electronic. There's really not a lot of magic here. And the integrity of the record, with paper, it's more like you get a witness to say, yeah, I saw that, I saw him sign on that date, there's my affidavit of execution. With electronic records, you can prove it by proof of the system's integrity. The system is set up to make these records accurate and work and stop people from fooling around with them and changing them, or by evidence of reliable encryption techniques to support the system's integrity. So all of a sudden, we're getting into a very cool interface between the geek realm and the legal realm, where I get to cross-examine the information technology manager of a corporation as to whether or not they had reliable encryption techniques, because I don't like that document and I want to prove it's not relevant. I might have a shot at it, who knows. In the absence of contrary evidence or reasonable grounds for doubt, if you can't prove the record itself, you just prove the system was working properly. And then you get the fail-safe that if the system wasn't working properly, which, as we know, you never have an electronic system that isn't working properly, right? Never happens. But if it wasn't working properly, as long as you can show that didn't affect the document. So you have a PDF document, password protected. So what if the network crashed? It's very likely that PDF document is still valid and has authenticity. And you can prove this by affidavits that you can introduce in court. Instead of bringing witnesses in to testify, we can actually just provide the affidavit. And as with nearly all affidavits, there's a right to cross-examine on it. So, any questions so far? I'm just motoring right along here talking about my favorite topic, which, you know, most people, if you say to them, I'm going to talk about records management and electronic records for an hour, they're going to say, I'm going to sit at home and watch paint dry and eat a banana, because that would be more exciting. So just shout at me or throw a bun or raise your hands if you have a question. The one thing I can threaten, I won't do this, but in law school we have a thing called the Socratic method, which is where the professor picks on the student that looks the most likely to not know the answer, and then embarrasses them when they don't. I can go Socratic if I have to, but you know, I'm hoping some of you will ask questions. So if you're operating only in Alberta, if you're going to start, you're going to take that warehouse of documents, and now you decided, okay, we've taken out the stuff that's not subject to the law in terms of interest in land and those kinds of things. We've gone and had a legal look at that, so we got this bunch of boxes over here, hopefully a small subset, that doesn't fit within the Electronic Transactions Act. We're going to hire tab and we're going to shred all the rest of the paper after we've scanned it in and indexed it. And if you're operating only in Alberta, you just fit within the Alberta legislation. It's fairly feasible to do it with a bit of thought. And then you classify the records with some kind of taxonomy that fits within the legislation. And you digitize what fits within the legislation and keep the paper for what doesn't. Then if you operate in multiple jurisdictions, you just do the same thing in those other jurisdictions. So if for example, Saskatchewan says that interests in land are admissible when they're in electronic form, and Alberta says no, you just meet the highest bar and keep the paper. That's not to say that you can't scan all those records of interest in land as well and have an electronic version of them. There's no law against that. It's just that if you need to prove that interest in land, you still need the paper. So you can use the digital stuff for operations. And I recommend you do, because it's a big pain to have most of your information in digital form and then some of it in paper. Because you're going to forget about the paper is what will happen. You'll get so used to the convenience of digital. So digitize everything if you like, but just keep in mind what you can't shred, because you may need it for legal purposes and you need it in paper. And of course, once the time for needing it in paper is run out, then you can shred it. And you can still have the digital if you want. And then I say fit within the records management best practices. So we get into retention periods and all those sorts of things that I'll talk a bit about later. So blindly digitizing the paper into an existing poor records management environment isn't going to help. This is your opportunity to think about how do we really manage this stuff so that it works very efficiently for the good of the organization and the good of the users. So if you've got a bad records management policy, just digitizing is not going to be the answer to your problems. You need to think about the policies as well and your practices and procedures. You should do this all with a view to current legal principles and best practices, and I'll shamelessly plug my paper that's in the materials again. If you're suffering from insomnia late one night, you can read it, and I guarantee it's the best soporific around. Should be done with a view to current legal principles, and this may present an opportunity to attain better legal compliance while reducing costs and enhancing efficiencies. Yes, you'll have a bump on the balance sheet when you take the paper and scan it in and index it and then shred it, but you will not have the ongoing costs not only of keeping the paper, but the real hidden cost with paper is transactional and internal costs. Everybody's running around hunting for stuff that they have trouble finding because you can't search paper. You can go into Iron Mountain and pull out that banker's box that says land use records 1979 to 1982, and then you find out it was wrongly labeled and it's not that at all. So now how do you find what you were looking for? If it's digital, you can search for it. So records management, some best practices. I'm going to check the time. We've got lots of time, I think. I'm told that when you're presenting, if you look at your watch, it's not rude as long as you don't yawn at the same time. I won't. You guys can yawn, but not me. So here's some of the key risks in records management. And the records managers in the room will say, yes, he's preaching to the choir. You might destroy records you're legally required to keep. That would be bad. And you might keep records the law requires you to destroy. That would also be bad. And a good example of that is now with modern privacy laws, personal information cannot be kept by you forever just because you want to. You can only keep it as long as you have a reasonable legal or business purpose for keeping it. And once you don't have those purposes, you must securely destroy that personal information. You can't keep it hanging around. That means you need some way of finding out and figuring out what in your records management system constitutes personal information. So you need to think about not only interest in land, you need to think about personal information. You might destroy records a sound litigation strategy would dictate that you keep. So you have someone who's a CEO and they sign a contract with a morals clause in it that says that if you have an affair with anyone in the office, we can fire you without paying you notice. And they have an affair with someone in the office and you fire them and you don't pay them notice. They sue you for wrongful dismissal. You better have a copy of that contract and not have shredded it, because if it's gone, you can't prove your defense. You might expose yourself to allegations of improper destruction. Now, here's a fancy lawyer's word for you, spoliation. That's spoilage of evidence or destruction of evidence. That can be very expensive, because in a lawsuit, you have an obligation. Once you know there's litigation coming, you have an obligation to the court to collect and preserve potentially relevant documents and records, whether they're digital or whether they are paper or both. And remember what I said, if digital and paper were from the same record, that's actually two records as far as the lawyers are concerned. They want to see both of them, and they may want the metadata too. There was the UBS case in the US had, I think, about a $1.2 billion award in damages. This is US, so it's bigger. And it was an employment discrimination suit. $600 million was the damages for what UBS did. The rest of it was damages for destroying 35 emails, punitive damages for spoliation of evidence. The court found, and the jury found, that those emails, which could have helped the plaintiffs, were deliberately destroyed. So once you have a lawsuit, and I'll get into this in a minute, you need to be stopping destruction sequences and thinking about what you have to keep. Or, even though you didn't do anything legally bad, you just destroyed stuff that's important for the business guys to use to run the business. So you got to keep stuff around for that. And the other risk is you're keeping a whole bunch of unneeded records, wasting space, clogging up systems, making people spend. Statistics say, again, 97% are made up, but statistics say the average worker in an office spends, pick a number, 3 hours a week, 5 hours a week, 13 months a year. I don't know what the answer is, but they spend a significant amount of time, probably feels like 13 months a year, running around trying to find stuff that if it was just available instantly, they wouldn't have wasted all that time and the company's money, frankly, looking for stuff. So unneeded records, this idea that, storage is cheap, we'll just keep everything forever, that's pretty dumb, frankly, because you're just making yourself very inefficient and you're breaking privacy laws because you're keeping stuff you shouldn't be keeping. Plus, once you've got a defensible reason for getting rid of documents on a good faith basis, you may want to get rid of them in case someone brings a late lawsuit later on. You should be able to say, we had a bona fide system, and that's in my paper as well, and we just destroyed this in good faith as a matter of course, and now we don't have it anymore, and they should have sued within the 10 years they had, not 30 years later. So best practices, part of an overall governance, corporate governance approach, it requires you act in good faith, this is from the legal point of view, and you set your schedules for destruction in good faith, and you respond to legal requirements, and again, that's in my paper. And keep records needed for organizational functions, keep what you need for legal requirements, keep it as long as you need it, and then get rid of it. And it's far easier with electronic records to manage timelines, the life cycle of records, because you can set them to auto-destruct. You can bring in technological policies that enable you to manage those records. If they're sitting out in Iron Mountain, and you've got 100,000 bankers boxes out there, and someone comes into your office and says, there's 100,000 bankers boxes at Iron Mountain, and we think most of the paper in there could be destroyed. So would you please drive over to Iron Mountain and go through those bankers boxes and destroy what should be destroyed? No, I have other plans. I quit. I'm not going to do it. So it's something you should be thinking about doing, managing the life cycle of records, and it's far easier with digital records. And personal information, as I mentioned, must be destroyed securely once you no longer have a bona fide business or legal purpose to have it. So keep classifications down to a small number. I actually saw a consultant once. Are there any consultants in the room? You're going to hate me. Came into a client of mine, and the client then approached me and said, we want a legal review of this records management policy. And they had 85 categories of records and drop-down menus. I said, that's ridiculous. I'm a fairly patient guy, and I'll handle 5. That's it. If you give me 6 categories, I'm not doing it. I'm out. Count me out. Some people might be loyal and do 10. Keep it down to a small number. There's no law against keeping something a bit longer. Even personal information, I can make a case for fairly long retention in order to keep the number of buckets and classifications down. You should have a permanent one. You should have one that's really long, one that's sort of long, and then one that's pretty short, and maybe some stuff you don't keep at all. And classify them and then handle them all that way. And if you handle them all that way with a good faith view to how you do it, you're probably okay. If you handle things along the line of, we're destroying this record because it relates to Swanson and we know he's going to sue us, so let's just shred it now. That's not good faith. You need to be doing it by classification. So when the retention period is up, you probably want legal sign off on this, but you can destroy it. Now destroying it means you better really destroy it, because if you don't, it's not working for you. Give you an example. I had a client years ago, we had a lawsuit, and this client thought that backup tapes were for retention purposes. So they had, yes, I know, backup tapes are for backup and disaster restoration, and if you got backup tapes that have information that's 7 years old on them, you got to really go, really? Why would I do that? It's probably in a format I can't even access anymore. Anyway, they had a bunch of backup tapes. We thought we'd located the relevant ones. There were 12 of them. We had to take them to Toronto and have them restored to the environment they were created in, which was an older version of Tivoli that had a bug in it. The bug fix had been released, but the bug fix had not been installed. So we needed a few guys with way more piercings than any human should have to work on this and restore it back. It was $10,000 a tape, so $12,000. Merrily we sail through the lawsuit, and then we get into discoveries, and somebody blurts out under oath, this is typical in a lawsuit. You usually have the first round of discoveries where you think you know everything, and then you have a subsequent smaller round where everyone gets sudden attacks of honesty and tells you things that you didn't know. So someone says, well, actually, I think we have a couple hundred more backup tapes in that closet back in the network area. And yes, they did have 200 more tapes or so. We didn't even bother counting them. They weren't labeled. We can't say under oath there's nothing relevant on it because we don't know. We have no idea. We don't even know if there's anything on it. And you can't search backup tapes. They're like the old VHS tape. You have to plug them into the socket, run them from the beginning to the end into a digital environment on a hard drive, and then you can search them. So you can't just take a peek at the backup tape and know what's on it. Plus, it's often not human readable anyway. So that became a very expensive lesson. The court ordered us to randomly test. First of all, the other side wanted all 200 restored. $10,000 each. You can do the math. Pretty expensive. The court said, no, we'll sample them randomly. So I think we sampled 20, and it turned out there was nothing on there that had any relationship with anything. And while we're on the topic of attacks of honesty, I had another one where a guy claimed that the hard drive that had some certain information on it, he just had no idea where it had gone. Didn't know. Second round of discoveries, I buried it in my garden last fall. True story. So we made him dig it up, and guess what? It still worked, and we got the stuff off. So anyway, destruction means no survivors. If you're going to destroy, destroy, because otherwise you defeated the whole purpose of it. If you've got a survivor and you get into a lawsuit, the court's going to probably make you produce it. So do it right. Legal holds. There's a lot about this in the Sedona Canada principles that you can download and read. But if you've got a destruction sequence for managing records, particularly digital records, if you get notice of an audit that you hadn't expected, some sort of court action, you know, if you have a pipeline burst in the United States, the US government and the state government immediately demand records from you, lots of records. And so you'll have all sorts of governmental subpoenas and so on that can affect you. Or common law obligations I've already talked about in civil litigation where you don't want to get into having destroyed evidence because the court at the very least will draw an adverse inference. They'll say, you know what, because you destroyed it, it must have been the worst imaginable record, so we're going to assume that that's what it meant. British American Tobacco was in a lawsuit in Australia quite a few years ago now, but they had been sued by a lady who was dying of cancer. She had a couple of months to live, and the court was asked to fast track it to trial. And the plaintiffs had the court kind of sympathetic, and then British American Tobacco got up and said, no, well, no, we just haven't been able to find those records, you know, we just don't have them, and we can't produce it. And the court said, well, you're going to produce them right away or else. And they said, well, sorry, we don't have them. So the court said, okay, we're going to trial in 2 months, and your statement of defense is gone because you haven't produced these records. You have no defense. We're just going to ask a jury how much money this lady gets. You cannot get up and say we didn't cause it because we're not going to listen to you. That's because they destroyed records. There's actually more to the story. In New York, in a similar lawsuit, they were fined $1 million a day until they coughed up records. And a whistleblower in the Australia case actually went to the media and said, well, actually, we have all the records. We've been hiding them on the island of Vanuatu in the Pacific for years and lying about the fact that they're gone. So it did not go well. Very bad. The plaintiff's lawyer's dream, you know, here I am. I've got this case and it's going to trial and all we're going to do is figure out how much I get. So you need to put a legal hold on anything that's potentially needed for a lawsuit or bad things can happen. So that means that memos have to go out to the custodians, as we call them, the employees that know about this stuff, so that they make sure they don't destroy things. Any questions? I'm just motoring on here. I can do this all day, you know. We got, what, 7 p.m. tonight? I think we're done? No dinner, though. The process used by organizations, this is what it is, a legal hold. You inform the employees of anticipated litigation and say, stop destroying stuff, or else you may be examined under oath. And by the way, just as an aside, something that companies often do with legal holds is they bring in their own IT people, God bless them, and they say, we want you to help us find all the records and preserve them and everything else. So you've now asked internal IT to do something they're not trained to do. They're going to be the people that search all the records and get up on the stand under oath in court and swear as to what they were able to find. They don't make the best witnesses. Here's the joke for you. How do you tell an extroverted geek? I classify myself as a geek, so they look at your shoes when they talk to you instead of their own. They don't make good witnesses in court. So don't inflict that on them. Bring in experts who can properly deal with this sort of stuff. But once you know there's a possible litigation coming, you need to work with counsel as records managers to ensure an immediate legal hold. And there's a whole bunch of process around this I'm not going to drill down into too much, but you really need to manage the case properly. That Air Canada and WestJet case was like a textbook example how to do it right, even though I'm the guy that did it and I'm saying it myself. From a business point of view, you want to, with records management, manage risk. It's all about risk. I think I have a slide coming up that says that. But really, you're just managing legal and operational risk. You're trying to keep the stuff you need available and you're trying to get rid of all the other stuff. So the main reason why you have a destruction sequence is to avoid costs, overhead, inconvenience, and all that sort of stuff, and keeping a whole pile of damaging and useless records. Every year we produce more information on Earth than we produced in all the years of history before. Seriously. It's more than doubling every year. It's just huge. So same happens within organizations. As files get bigger, you know, we used to have text files, then we got Word files, and now we got all sorts of rich content things with links in them and digitized video and so on. That stuff just eats up more and more space. So you really need to start getting efficient about it. So proper policies make it more likely you know what you have and don't have. It makes it more likely that you'll have the right stuff available and easy to locate, and they're authentic and accurate, admissible and probative, all great lawyers' words. It means they work in court. And less likely there's some kind of risk that exists in the form of unknown or difficult to locate records, like 200 backup tapes in that closet. You just don't want to have that happen. It's way too expensive, and it slows things down. So here's a bunch of other points. I know I'm preaching to the choir here, but proper records management, if you digitize as much of the paper as possible and you're doing this right, you'll start saving a lot of money over time. So yes, there's a big bump on the balance sheet now, as I mentioned, but over time you should recover that return on investment. And of course, as prudent managers, you want to figure out what that period of time is and what the return is. But it makes it a lot less likely that all the bad things I've been talking about will happen. Because without a proper policy, discovery and litigation, which is, okay, I'm going to say this out loud, it's really anal proctology. That's what it is. Here's three, this is in the paper I've given you, 3 general principles from a legal point of view. First of all, your records retention policy needs to be reasonable. Reasonable is a very common concept in the law, and it's like pornography. We all know it when we see it. But we may differ. Again, like I said, ask 2 lawyers an opinion and get 3 answers. Is the policy reasonable considering the facts and circumstances? And are the retention periods reasonable? Do they make sense? Does it respond to litigation needs and the circumstances? So if you've never been sued, you may not know what exactly responsive is, so you make your best effort to figure it out. But if you're getting sued for the same thing over and over and over and over, you're an oil company, you have a lot of wells out there, and you're always being sued by landowners because they smell bad, you probably want to keep the records about why they do or don't smell bad for a reasonable period of time, because you know they're going to be needed for a lawsuit. It's too cute to just start destroying them. So you need to respond to all of that, and it has to be in good faith. You can't be hiding evidence on the island nation of Vanuatu to deprive plaintiffs of their case against you as a tobacco company. That's not good faith. Good faith, again, is like reasonableness. We know it when we see it. So if you know that a record's going to be relevant at a future date, or any reasonable person would say, yeah, you're going to need those, don't destroy them. You know, it's all common sense. Of course, nothing as uncommon as common sense. How long do I need to keep a record around for lawsuits? And the answer is the Alberta Limitations Act, which sets out the limitation periods for suing in most cases, says 2 years when you know or ought to know of a claim. So if I'm working for you and you fire me, I know I got fired, I got 2 years to sue. If you are a surgeon and you operate on me and you leave a scalpel in my stomach, I don't know about it until 6 years later, and when the scalpel moves and slices me open, and I go, wow, a scalpel sticking out, I better sue the surgeon. I'm still within the drop dead period of 10 years, drop dead, not being related to the fact there's a scalpel in me. But so whenever you know that you have a claim, whenever you know or reasonably should know, that's when the period starts running of 2 years. But at 10 years out, that's it. It's called a drop dead period. Courts might make some exceptions, but generally speaking, at 10 years out, that's it. You're not going to get sued by that party for that claim. Even if they discovered it, 11 years out, too bad. They can sue with a statement of claim which remains in force for a year. So if you're going to keep records to defend against claims that someone might figure out later, you need to keep them all for 10 years. That's not long enough, because they may sue you one day before the 10 years runs out. So you need another year. Actually, you need more, because that statement of claim, they may file it and not serve you for almost another year. So you're out to almost 11. And when you get sued, you're going to have to go, wow, we got sued for something that happened 11 years ago. Where's the records? So I make it 12. That's kind of the magic number. And every other province or jurisdiction is going to vary. The world is flat. That's globalization. Everything's cross-border nowadays, particularly so in the digital world. Information security and cybersecurity, like the $20,000 problem that UFC have with ransomware, huge issue. Big data should have been a separate bullet. Cloud computing, lots of issues around outsourcing to cloud computing, artificial intelligence and robotics and Industry 4.0. This all sort of floats around in the same area as digital records. They all interface. They're all sort of engines that are lifting in the whole economy. And the exponentially increasing rate of change. So we're going to have as much technological innovation in the next 20 years as we did from 1750 to last year. True. And if you want to go back in history before 1750 and get the same amount of technical development, you have to go to 12,000 BC.